Our jury is back at the courtroom seated. Defendant and counsel present, please be seated. Thank you for your patience. As I indicated a moment ago, members of the jury, you've heard all the evidence with respect to aggravating circumstances, mitigating circumstances, and now the lawyers for the state and lawyers for the defense will have their opportunity to make arguments to you. Mr. Brewer.
May it please the court, counsel. In this courtroom, for this defendant, in this moment, justice and death are not abstract concepts. Because the determination before you, ladies and gentlemen, is whether it will be just and right for Dontae Morris to receive the same eternal sentence that he ruthlessly and without justification and provocation imposed upon officers Curtis and Kokat on June 29th of 2010. I'm sorry, Your Honor, could that be stopped? Please trust me.
I'm trying, sir.
May I pause for a minute? Okay, thanks. That's all right. Any government that has the power to exercise, or excuse me, to execute one of its citizens, I submit to you, must do so with great restraint and only under exceptional circumstances. This defendant, Dontae Rashawn Morris, and his crimes of first-degree murder of officers Curtis and Kokat present to you just such exceptional circumstances that merit the imposition of the death penalty, that cry out for the imposition of the death penalty. You'll not see me raise my voice or pound my fists today, because your decision must be one not based upon emotion, but based upon a logical application of the law to the evidence you've heard, so that you can come to a just and lawful advisory sentence. And I suggest to you, and I urge to you, that reasoned analysis and reasoned application of the law will lead you to one and only one conclusion: that Dontae Rashawn Morris deserves to be put to death for his homicides of officers Curtis and Kokat. On May 30th of 2010, a mere 30 days before he killed the officers, Dontae Rashawn Morris took the life of Rodney Jones. So if you had any idea or concern that the events of June 29th of 2010 were just Dontae Morris at a bad day of his life, you can rest assured that that wasn't the case. On May 30th, this defendant fired a weapon into the head of Rodney Jones. Why is that significant for your consideration? Because the state of Florida has to prove to you beyond a reasonable doubt the existence of at least one aggravating circumstance, and I submit to you there's three that have been proven beyond a reasonable doubt. The very first one I'm going to talk to you about, I suggest to you and urge you is entitled to great weight in your consideration. Was this defendant ever convicted of a prior capital felony? And the answer resoundingly and beyond any reasonable doubt or any doubt at all is yes. He killed Rodney Jones. These photos are not here to inflame your passion, but you must not lose sight of, we're not talking about victims whose names appear on paper, but human beings whose lives were taken by this defendant for no just cause, no discernible reason, except selfish ones. Introduced into evidence in this penalty phase were some photographs that pertain to the Rodney Jones homicide. You'll have these back there for your consideration. And I show you the location of the gunshot wound to Rodney Jones' head. And the location where Rodney Jones fell and where he was killed, right alongside a car with an open door. Reminiscent of some other facts. And look at the efficiency which demonstrates the ruthlessness of this defendant's prior convictions. The efficiencies as demonstrated by the location of the wounds to Rodney Jones in the head, to Officer Kokab in the head, to Officer Curtis in the head. I suggest to you it's not unreasonable for you to conclude what was going through Dontae Morris's mind at the time Officer Curtis lit up Courtney Brantley's car with his overhead lights was his prior conduct on May 30th of 2010. That aggravating circumstance, I suggest to you, is persuasive, is powerful, and in and of itself merits the imposition of the death penalty. The way the law in Florida works, ladies and gentlemen, is that, and you'll be instructed about this, is that when you have two homicides that occur simultaneous or within moments of one another or in the same event, as you have here with the deaths of Curtis and Officers Curtis and Kokab, that for the sentence, advisory sentence, you're to return as to the count of premeditated murder concerning Officer Curtis, you can consider as an aggravating circumstance his murder of Officer Kokab. That's a contemporaneous prior felony conviction, and the same can be done for the other count. For Officer Kokab's murder, you can consider as an aggravating circumstance in your determination his simultaneous or almost simultaneous killing of Officer Curtis. But you understand, these three homicides constitute one lawful aggravating circumstance. 3 deaths, 1 aggravating circumstance. In and of itself, that justifies imposition of the death penalty. And he was also convicted in the Rodney Jones case of robbery, a violent, attempted robbery, a violent prior felony offense. In addition, the state of Florida has proved to you beyond and to the exclusion of any reasonable doubt another or a second aggravating circumstance, that the murders of officers Kokab and Curtis were committed for the purpose of preventing or avoiding a lawful arrest or effecting escape from custody. Ladies and gentlemen, that was the entire motive, the entire reason, the self-serving reason that this defendant killed those officers. You saw the tape on 2 occasions. Was he abused by Officer Curtis and Kokab? Did you see anything unlawful or unjust in their exercise of their duties that night? No. The reason he shot them in close range in the head was to enable him to flee, to avoid arrest or to escape custody. That's been proven beyond and to the exclusion of every reasonable doubt, and in fact is reflected in your verdict in the first phase of this trial, in the guilt phase. I suggest to you that that aggravating circumstance also merits, standing alone, the imposition of the death sentence. But you don't have to rely just upon the first or the second aggravating circumstance that I've described to you, because you have a third aggravating circumstance, which I'll discuss with you in a few minutes. You've heard evidence today from the defense, which was presented to you through 4 witnesses concerning mitigation. And you should consider that and assign to that evidence whatever weight you determine is right and logical and just. A couple points I want to raise about the mitigation you heard, however. First, you'll hear an instruction, and I greatly paraphrase, that the weighing process is not a mechanical process, meaning it's not a numbers game. The side that presents more aggravators in terms of numbers than mitigators doesn't win your vote, because you get to assign whatever weight you think is appropriate. If you believe in your individual and collective analysis that the fact that this defendant has murdered 3 people is entitled to so great weight that it outweighs all mitigation, even though the facts that may comprise the mitigation may be 30 or 40 separate facts, then you're entitled to do so. The fact that you may hear proposed mitigation amounting to 20 or 25 separate points does not, in and of itself, require you to vote for a life sentence. It's not a numbers game, because you're to assign, based upon your reasoned analysis, the weight to these aggravators and mitigators. Now, I am not going to stand before you and suggest for a moment that Miss Celicia Watson's giving birth to a child when she was a child was not a tremendous challenge for her. It is evident, as you heard in this courtroom, that she was not prepared to raise a child at that moment in her life. And you can attribute to that whatever weight you think is appropriate. But look at the mitigation in its entirety to determine whether the mitigation appropriately explains this defendant's murderous conduct such that it outweighs the aggravating circumstance of the multiple deaths. She was a 16-year-old child herself at the time of her birth to this defendant. But the evidence establishes to you that at each and every stage of this defendant's life, there was family support, whether it be extended family from paternal grandparents or from her own grandparent or from Dontae Morris's maternal grandparents, Celicia Watson's own parents. There was always somebody there to love, to shelter, and to care for Dontae Morris. I suggest to you that mitigation that you've heard is entitled to very slim marginal weight in your analysis. What you heard was not that Dontae Morris was abandoned. He was not discarded. He was not a latchkey kid. He was not shunted from one facility to the next, and orphanages, etc., etc., etc. But Mrs. Watson, throughout her life, took great care and steps, as any mother would, to provide him a normal life, the opportunities that are available to many kids in this country. She made sure that he was at school. She made sure that he did his homework. She exposed him and encouraged him in a church life and made sure he attended with them. She encouraged and supported at sacrifice, financial and in terms of her time, his athletic career as a juvenile and an adolescent. Driving him to those numerous practices, paying the fees that come with youth sports, taking the time that she may have wanted to spend for her own personal life and devoting it to her son's life so he could have the opportunity of youth sports and the discipline and the values and the team dynamic that sports encourages and molds young men. She gave him that opportunity. She made sure that this defendant didn't have idle time in the summers. As unprepared as she was at the outset to care for this defendant, having suffered postpartum depression, she tried and gave him a lot of opportunity. She made sure in the summers he was either at the boys' club or in track. And when he couldn't be in school for whatever reason, he wasn't a latchkey kid. He wasn't left at home behind closed doors with a remote controller and a video game. She kept him close to her at work. Dontae Morris did not lead a deprived childhood. There was difficulty, there was challenge, and there was discord when Miss Watson chose to end certain relationships, undoubtedly. And that's not easy on any child. To suggest otherwise would be just ridiculous. But nothing that rises to the level of mitigating his murderous conduct within 30 days of killing 3 human beings point blank with a gun. Dontae Morris, as the mitigation has suggested to you, has expressed throughout his life care, concern, and love for his family members. And you can contrast that and give that whatever weight you think appropriate when you contrast it with the care, concern that he extended to Officers Curtis and Kokab through the barrel of that gun. A lot of the mitigation evidence you heard essentially stopped in 2000, 2001. These witnesses had no contact with him, or very minimal contact with him in the last 8 years that led up to him. There's no real mitigation that gives you any insight into why Dontae Morris made the deliberate choices to take 3 lives, to remove 3 citizens from the streets of Hillsborough County. The third aggravating circumstance that that the state urges for your consideration, and that has been proved to you by the evidence beyond and to the exclusion of every reasonable doubt, is that Officers Curtis and Kokab were law enforcement officers killed during the performance of their duties. There is no doubt that that has been proven. That, in and of itself, I suggest to you, merits the imposition of the death penalty, even aside from the fact he has already done this one time before, 30 days earlier. And why does the law afford such a special designation, such a special respect for law enforcement officers who are killed in the line of duty, such that that the law allows that aggravating circumstance to sustain a death penalty standing alone? Well, and you've heard this before. You probably heard it in civics class in junior high or high school. But the fundamental founding premise of our society is that our society is one of laws and not of men. That's what separates and distinguishes us from dictatorships, from tyrannical regimes. And that those fundamental principles you've heard about since you were children, life, liberty, and the pursuit of happiness, all men being created equal, those are lofty principles in the abstract until there is someone to protect and defend those principles on a daily basis in our streets. And that frontline defense is gladly undertaken by our law enforcement officers. Law enforcement on a daily basis is the first line of defense of our democracy, of those fundamental principles that separate ours from any other society in this country. My words on this subject are probably inadequate. I would ask you to consider the words of Abraham Lincoln in 1838, when one of his first known speeches, he was 28 years old, he was speaking in Springfield, Illinois, and he was speaking out against a series of mob violence and lynchings that had occurred throughout Missouri and Springfield. And he addressed the significance of the respect and reverence for our laws that is a fundamental principle in our society that law enforcement officers protect. When he wrote, or when he spoke, Let reverence for the laws be breathed by every American mother to the lisping babe that prattles on her lap. Let it be taught in schools, in seminaries, and in colleges. Let it be written in primers, spelling books, and in almanacs. Let it be preached from the pulpit, proclaimed in legislative halls, and enforced in courts of justice. And in short, let it become the political religion of our nation. And let the old and the young, the rich and the poor, the grave and the gay, of all sexes and tongues, and colors and conditions, sacrifice unceasingly upon its altars. This is an aggravating circumstance because Officers Curtis and Kokab, when they were killed in the line of duty, gave the ultimate sacrifice in the reverence and protection for our laws, our protections, our liberties. The tragic irony in this case is that Officers Dave Curtis and Jeffrey Kokab were killed during their protection and their enforcement of those constitutional freedoms and rights and protections that you have seen on display in this courtroom in these proceedings over the last few weeks. There is nothing that you have heard, I suggest to you, that mitigates in any sense imaginable this defendant's premeditated, ruthless, needless, homicidal acts. Yours does not need to be a unanimous advisory sentence. 12 of you do not have to vote the same way, unlike what's required in the first or the guilt phase. But there's no reason your advisory sentence can not be unanimous. I encourage you, I suggest to you, I ask you to return a unanimous advisory sentence that this defendant be sentenced to death for his killings of Officers Dave Curtis and Jeffrey Kokab. Thank you for your considered attention.
Yes, Your Honor. May I have just a moment to have one of my co-counsel help me put up a chart?
Yes, sir. That's fine.
You got a logistical problem.
Yeah, but this one will have to remove one. Or just, if you just pick that one over there.
Can the folks see that? Good afternoon, ladies and gentlemen. I certainly agree with what Mr. Pruna told you. This is a most serious and real proceeding. This is not a made-for-television movie or a police or detective show. This is the most serious kind of reality there is. I believe you are taking it seriously, and I appreciate, on behalf of the defendant, you're paying close attention to everything that's gone on in this case. I would start also by saying that I agree with Mr. Pruner's statement that Florida law requires that the death penalty be used with what I think his words were, great restraint and only under exceptional circumstances. Today, you're going to be called on to make a recommendation as to the sentence of Dontae Morris. That recommendation will have to be either that he is sentenced to be put to death by the state of Florida, or that he will be sentenced to life imprisonment without any possibility of parole. Those are the only two choices. Also, I would urge you to remember that in Florida, a life sentence without possibility of parole means just that. Dontae Morris would die in prison. He will never be free. There is no parole in this state. We would urge you to consider this. The law of Florida, while it permits the use of the death penalty in those exceptional cases of which Mr. Pruner spoke, limits that, the imposition of that penalty greatly. In that sense, Florida law favors life. I say that it favors life in that our system of laws that was mentioned by the Assistant State Attorney is founded on the concept of the rule of law, yes, but underpinning all of that is the respect our society and our culture has always had for the preciousness of each individual and the right of each individual to dignity and fairness and equal treatment. That is the foundation. In accordance with that, Florida law favors life in that it requires you to go through this process that you're going through right now before the imposition of the death penalty can even be considered. It requires that you listen, as you have, to the evidence, including the evidence in the guilt phase, evidence that establishes, or the state asserts establishes, aggravating circumstances. I won't repeat in any detail those circumstances. Mr. Pruner covered those with you. I will remark on them a little bit later, but that is your first duty. You must find that those, at least one of those aggravating circumstances have been proven beyond a reasonable doubt. And then you also have to listen to the mitigating circumstance, the evidence of that, and determine whether those items of evidence have been proven by preponderance of the evidence. Then there is, as the judge will instruct you, and I'm not going to attempt to give you the instruction, he'll be doing that, but I'll kind of paraphrase it. You are required to consider that evidence, determine whether the burden of proof has been met, and then weigh it carefully, each individually, each in accordance with your own understanding of the facts, both aggravating circumstances, mitigating circumstances, both, and your own judgment as to what is the right thing to do, what is the appropriate sentence. No one can make that decision for you. That is an individual decision. The law of Florida, while it permits you, if you have determined that one aggravating circumstance or more have been proven beyond a reasonable doubt, and that the aggravating circumstances are not outweighed by the mitigating circumstances, it permits you to recommend to the court that the sentence of death be imposed. But it never requires you to do so. Regardless of your judgment of the aggravating and mitigating circumstances, if you've done your duty, considering those factors and weighing them in your own mind, and searching your own conscience, if you do not find that the death penalty is an appropriate sentence in this case, you are not required under any circumstances to recommend that it be imposed. That is another way that the law of Florida favors life. It permits a jury in its recommendation to recommend that mercy be shown. You always have the right to do that. I would urge you also, we've talked a little about this previously, but I want to remind you that as has been read to you in an instruction, and the judge will, I believe, read that same instruction over again, he's read it here today, your decision is called a sentencing recommendation. But the law also requires that the judge give that recommendation great weight. And while the judge makes that final legal decision because the law requires that he do an independent review to determine that there is legally sufficient evidence and that all the requirements of the sentencing laws have been properly met, it would be a very unusual event for a judge to impose a sentence other than what you recommend. The aggravating circumstances have been discussed with you by the Assistant State Attorney. I'm not going to really argue too much about the three that he discussed. I am, however, going to make certain that this is clear, that the fact that you found Dontae Morris guilty of premeditated first-degree murder is not an aggravator. That was the charge against him, that it was premeditated first-degree murder. Your verdict found him guilty of that, but that does not serve as an aggravator. Only the aggravators that were listed by the state and provided by law may be considered, and that's not one of them in this case. You also heard victim impact evidence, the statements that were read by family members and friends of the victims in this case. Florida law provides that you be allowed to hear that, and they be allowed to explain to you, as they did, the uniqueness of the qualities of their loved ones and the resultant loss to them and to the community by their deaths. The judge has admonished you that that information, that those facts that were told to you by these family members is not an aggravating circumstance. Truly, it is always a very emotional thing almost everyone reacts to what is truly a sad and tragic situation. But it is not a factor that you can weigh in determining the appropriate sentence to recommend. And that's not the purpose for which it is presented to you. With regard to the mitigating factors, let me tell you that, and we have a chart here. Unfortunately, we got 3 pieces and 2 easels, so I'll have to kind of, I'm not going to go through all of it. I'm sure that you can look through it and you remember the testimony. We tried to list a kind of a summary of the mitigating testimony that you heard today from family members. What I think is important is that you think about these things. And there's, I knew it was going to be that. And there's that as well. You heard this testimony. This is just kind of a little aid to remind you. Set this here for a moment. What the law in Florida requires is that we present you with mitigating circumstances, because each case must be judged on its own individual merits and in accordance with the factors the law says may be considered. The victims in this case are tragic. Mr. Pruner said they were, of course, human beings. That's true. And their loss is tragic. No one would deny that. Dontae Morris is a human being as well, and is entitled to have you consider all the facts before making your recommendation. These mitigating facts that we have presented to you do indicate some problems that developed in Mr. Morris's early teenage years, where something went badly awry. They do not explain why. They are merely suggestive of some factors that may have been influencing him in a wrongful direction. They are not excuses. There are no excuses. That's not the purpose of mitigation. The purpose of mitigation is to let you understand the entirety of the situation. And what some of these things, these mitigating circumstances that we have discussed with you, that are on that chart, that you heard from the witness stand, show you, is that with Dontae Morris, as with all humans, there are positive things and there are negative things. That could be said for everyone. We're asking today that you impose a very serious punishment, life imprisonment without parole, possibility of parole ever. Nobody can deny that is a most serious punishment, which also protects society. We ask you to search your conscience and determine whether, in light of all that you know about this case, it is the right and appropriate thing to do in your judgment to recommend that the state of Florida kill this man. That is a somber responsibility. We urge you to assert whatever values are yours, make your judgment, and to show mercy in this case. Because you believe it is the right thing to do. It doesn't matter what Dontae Morris thought or somebody else thought. You're the decision maker in making this recommendation. What you think is right is what is important here. I believe you will take that seriously. We urge you to do that. And I most respectfully ask you to give very serious consideration to and to show mercy by recommending a life sentence without possibility of parole. Thank you very much, ladies and gentlemen. Yes, sir.
For the benefit of the audience, I'm going to instruct the jury, if anyone wants to leave the courtroom, do so now. I won't want any movement in or out of the courtroom while I'm instructing the jury. As I've told you, members of the jury, each of you will have a written copy of these instructions to read along with me. I'm required by law to read them to you. You can make whatever notations you wish. You can have these with you when you go back to deliberate. I just ask that as I read them to you that we not get ahead of each other or behind each other. Everyone have a copy? Member of the jury, it is now your duty to advise the court as to the punishment that should be imposed upon Dontae R. Morris for the crime of first-degree murder as to each count. You must follow the law that I will now give you and render an advisory sentence as to each count based upon your determination as to whether sufficient aggravating circumstances exist to justify the imposition of the death penalty or whether sufficient mitigating circumstances exist that outweigh any aggravating circumstances found to exist. The definitions of the aggravating and mitigating circumstances will be given to you in just a few moments. As I've told you, the final decision as to which punishment shall be imposed is the responsibility of the judge. As the trial judge, that responsibility will fall on me. However, the law requires you to render as to each count an advisory sentence as to which punishment should be imposed. Life imprisonment without the possibility of parole or the death penalty. Although the recommendation of the jury as to the penalty is advisory in nature and is not binding on the judge, the jury recommendation must be given great weight and deference by the judge in determining which punishment to impose. Your advisory sentence should be based on the evidence of aggravating and mitigating circumstances that you heard during the first phase of the trial and the evidence that has been presented to you in these second phase proceedings. It is up to you as jurors to decide what evidence is reliable. You should use your common sense in deciding which evidence is the best evidence and which evidence should not be relied upon in considering your advisory sentences. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some specific things you should consider are the following. 1, did the witness seem to have the opportunity to see and know the things about which that witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the lawyer's questions? 4, did the witness have some interest in how this case should be decided? 5, did the witness's testimony agree with the other testimony and other evidence in the case? 6, had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of that witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? And 9, was it proved that the witness had been convicted of a felony or a crime involving dishonesty, on page 2. You may rely upon your own conclusion about a witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe the witness to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. A defendant in a criminal case has a constitutional right to not testify at any stage of the proceedings. You must not draw any inference from the fact that Dontae Morris did not testify. The following are some general rules that will apply to your discussion. You must follow these rules in order to return lawful recommendations. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your recommendations will be a miscarriage of justice. There is no reason for failing to follow the law. Everyone is depending upon you to make a wise and legal decision. 2. Your recommendations must be based only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3. Your recommendations must not be based on the fact that you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about things should not influence your recommendations. 5. It is entirely proper for a lawyer to talk to a witness about what testimony that witness would give if called to the courtroom. A witness should not be discredited by talking to a lawyer about his or her testimony. 6. Your recommendations should not be influenced by feelings of prejudice or by racial or ethnic bias or by sympathy. Your recommendations must be based on the evidence and on the law contained in these instructions. An aggravating circumstance is a standard to guide the jury in making the choice between the alternative recommendations of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance which increases the gravity of a crime or the harm to a victim. An aggravating circumstance must be proved beyond reasonable doubt before you may consider it in arriving at your recommendation. In order to consider the death penalty as a possible penalty, you must determine that at least one aggravating circumstance has been proven, on page 3. The state has the burden to prove each aggravating circumstance beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt or a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating circumstance if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating circumstance exists, or if you have a conviction that it exists, it is one which is not stable but one which wavers and vacillates, then the aggravating circumstance has not been proved beyond every reasonable doubt, and you must not consider it in rendering an advisory sentence to the court. It is to the evidence introduced during the first phase of this trial and in the second phase proceeding, and to it alone that you're to look for that proof. A reasonable doubt as to the existence of an aggravating circumstance may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt as to the existence of an aggravating circumstance, you should find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating circumstance does exist and give it whatever weight you determine it should receive. The aggravating circumstances that you may consider are limited to any of the following that you find are established by the evidence. 1. The defendant was previously convicted of another capital felony or of a felony involving the use or threat of use of force to a person. In this instruction, I'll instruct you that the crime of first-degree felony murder committed during attempted robbery is a capital felony. I'll further instruct you that the crime of attempted robbery is a felony involving the use or threat of use of violence to a person. And I'll further instruct you that the contemporaneous commission of the capital murder of one person is a previous conviction as it pertains to the capital murder of a second person. 2. The capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. 3. The victim of the capital felony was a law enforcement officer engaged in the performance of his official duties. The state may not rely upon a single aspect of an offense to establish more than one aggravating circumstance. Therefore, if you find that 2 or more aggravating circumstances are proven beyond reasonable doubt by a single aspect of an offense, you are to consider that as supporting only one aggravating circumstance. If you find that the aggravating circumstances do not justify the death penalty, your advisory sentence would be one of life imprisonment without possibility of parole. Should you find sufficient aggravating circumstances do exist to justify recommending the imposition of the death penalty, It will then be your duty to determine whether the mitigating circumstances outweigh the aggravating circumstances that you find to exist. We're on page 4. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything in the life of Dontae Morris which might indicate that the death penalty is not appropriate for him. In other words, a mitigating circumstance may include any aspect of his character or background or life or any circumstance of the offenses that reasonably indicate that the death penalty is not an appropriate sentence. A mitigating circumstance need not be proved beyond reasonable doubt by Dontae Morris. A mitigating circumstance need only be proved by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give it such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Among the mitigating circumstances you may consider are the existence of any factors in Dontae Morris's character, background, or life, or the circumstances of the offenses that would mitigate against the imposition of the death penalty, including, but not limited to, evidence that he was born to a 16-year-old unwed mother, that his father was murdered when he was 2 years old and the murder remains unsolved, that he was raised by his maternal grandmother, Phyllis Hunter, during his early years, but her health was extremely fragile and she could not adequately care for him, that his mother did not bond with him, she suffered severe postpartum depression and was a child herself, that he began to bond with his stepfather, but the stepfather soon became a crack addict and left the family and him, that he was raised without a father or a male role model, that his mother gave birth to 2 other children, his brother Dwayne and his sister Audra, that his mother eventually married the father of her other children, Dwayne Calloway Sr., that during his early years and into high school he was an athlete, a football wide receiver and track sprinter, that his mother tried with limited success to integrate him into her new traditional family unit, but however he felt isolated, left out, and alone, that he had to watch his siblings have the support and affection of a father, a critical developmental support which he never had, that at 14 years old he became the man of the house when his mother left her new husband, Dwayne Calloway Sr., the father of his 2 half-siblings, that he suffered with his mother through a long and bitter divorce, after which the family moved in with another man, Mr. Gary Watson, with whom Dontae did not get along, that at 15 years of age he was asked to leave the home, that the family conflict was encouraged by his former stepfather, Dwayne Calloway Sr., who undermined by manipulating and encouraging the children to resist his mother and new stepfather, that after he left his mother's home, Mr. Calloway also rejected him, that he lived for a time with his paternal grandparents, the Morrises, but they failed to control or discipline him, that he was very close to his Aunt Charlotte Hamilton and his cousin Devon Hamilton, who were positive influences and a healthy support system for him, but they moved to Jacksonville during the time of his family turmoil, that he has maintained contact with and concern for his family members, that he has a son and has remained in contact with the child and has maintained a supportive relationship with him, that he has maintained a caring and supportive relationship with his cousin and other family members, even while he has been in jail, that his early teen years were unstable, that he was uprooted several times and attended 5 different schools and eventually dropped out and lived in various relatives' homes over a 2-year period, that he became involved during that time in the juvenile justice system, during the family turmoil, and in the midst of his critical time of development in his early years, that his mother, Celicia Watson, obtained counseling for him, that she also petitioned juvenile authorities and the court multiple times to get more stringent treatment programs for him, but her requests were refused because she was told that his offenses were not serious enough, that he got no meaningful help or guidance during his critical juncture in his development as a teenager, and that he has expressed remorse for killing. On page 5. If one or more aggravating circumstances are established, you should consider all the evidence tending to establish one or more mitigating circumstances and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence that should be imposed. You have heard evidence about the impact of this homicide on the family, friends, and community of David Curtis and of Jeffrey Kokat. This evidence was presented to you to show each man's uniqueness as an individual and the resultant loss by his death. However, you may not consider this evidence as an aggravating circumstance. Your recommendation to the court must be based on the aggravating circumstances and the mitigating circumstances upon which you have been instructed. The sentence that you recommended to the court in each count must be based on the facts as you find them from the evidence and the law. If, after weighing the aggravating and mitigating circumstances, you determine that at least one aggravating circumstance is found to exist, and that the mitigating circumstances do not outweigh the aggravating circumstances, or, in the absence of mitigating factors, that the aggravating factors alone are sufficient, you may recommend that a sentence of death be imposed rather than a sentence of life in prison without the possibility of parole. Regardless of your finding in this respect, however, you are neither compelled nor required to recommend a sentence of death. If, on the other hand, you determine that no aggravating circumstances are found to exist, or that the mitigating circumstances outweigh the aggravating circumstances, or in the absence of mitigating factors, that the aggravating factors alone are not sufficient, you must recommend imposition of a sentence of life in prison without the possibility of parole rather than a sentence of death. The process of weighing and aggravating and mitigating circumstances to determine the proper punishment is not a mechanical process. The law contemplates that different factors may be given different weights or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. In these proceedings, it is not necessary that the advisory sentences of the jury be unanimous. The fact that the jury can recommend a sentence of life imprisonment without parole or recommend a sentence of death on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you ballot, you should carefully weigh, sift, and consider the evidence, realizing that human life is at stake, and bring your best judgment to bear in reaching your advisory sentences. Page 6. If a majority of the jury, by 7 or more, determines that Dontae R. Marr should be sentenced to death, your advisory sentences to each count will be a majority of the jury by a vote of blank to blank advises and recommends to the court that it impose a sentence, the death penalty upon Dontae Morris. On the other hand, if by 6 or more votes the jury determines that Dontae Morris should be sentenced to death, that she should be sentenced to life without possibility of parole. There's an error there. Your advisory sentence will be the jury advises and recommends to the court that it impose a sentence of life imprisonment without possibility of parole upon Dontae Morris. When you've reached advisory sentence in conformity with these instructions, that form of recommendation should be signed by your foreperson, dated and returned to the court. There is no time set for a jury to reach an advisory sentence. Sometimes it takes only a few minutes, other times it takes hours or even days. It all depends upon the complexity of the case, the issues involved, and the makeup of the individual jury. You should take sufficient time to fairly discuss the evidence and arrive at a well-reasoned recommendation. You will now retire to consider your recommendation on each count as to the penalty to be imposed upon Dontae Morris. Before I recess you, let me ask the counsel to approach. Turn to the very last page of your packet, page 6 of 6. There's a typographical error that I'll ask you to correct. The second full paragraph where it says, on the other hand, if by 6 or more votes the jury determines that Dontae Morris should be sentenced to, it says death, that should read to life imprisonment without possibility of parole. I'm going to get that. Yes, sir.
Ours read should not be sentenced to death. There's the word not.
Then I stand corrected. There's nothing. There's no error there. You did it correctly.
I'm confused, Judge. May I at this moment?
It does read correctly.
Counsel's approach.
Yes.
Bear with us 1 minute. Sure that I've said everything that I should say. I think I had a slip of the tongue. I'll reread page 6 of 6 to the jury again. If a majority of the jury by 7 or more determines that Dontae Morris should be sentenced to death, your advisory sentence as to each count will be: a majority of the jury by a vote of blank to blank advises and recommends to the court that it impose the death penalty upon Dontae Morris. On the other hand, if by 6 or more votes the jury determines that Dontae Morris should not be sentenced to death, your advisory sentence will be: the jury advises and recommends to the court that it impose a sentence of life imprisonment without possibility of parole upon Dontae Morris. When you reach advisory sentences in conformity with these instructions, that form of recommendation should be signed by your foreperson, dated, and returned to the court. There is no set time for a jury to reach an advisory sentence. Sometimes it takes only a few minutes, other times it takes hours or even days. It all depends upon the complexity of the case, the issues involved, and the makeup of the individual jury. You should take sufficient time to fairly discuss the evidence and arrive at a well-reasoned recommendation. You will now retire to consider your recommendation on each count as to the penalty to be imposed upon Dontae Morris. So the way it was typed originally was correct. Thank you for pointing that out. Now, there have been 12 plus 4 alternates. The alternates know who you are. As I explained to you, by law, the alternates are required to participate in this proceeding. So now the original regular 12 jurors will go to deliberate. The four alternates will please remain seated because I need to talk with you further.
All rise, and we bring you forward.
Our 12 jurors have left the courtroom. You can all be seated. You 4 folks were alternates. And again, I thank you for your participation at this point. I explained to you that I'm sorry that you have to come back for this, but the law requires it. And the reason for that was that in the event anything happened to one of the other jurors at any time, we would have to rely on alternates. I normally would, in any case, would be permitted to let the alternates go and let you go about your daily lives, but the law required this. From this point forward, you're no longer obviously sequestered. You're at liberty to talk about this case with whomever you wish. I will say this to you. I want to thank you for the time that you gave us all in considering this case. I want to take a moment to advise you some privileges that you enjoy as a former juror. Please understand that no juror can ever be required to talk about what you discussed in the jury room except by court order. For many years, we've recognized that because we have to rely on individuals such as yourself to decide all kinds of cases, that we should allow your votes and your deliberations to remain your private affair as long as you wish. Therefore, the law gives you the unique privilege about not talking about your work, to not talk about your work. Conversely, however, you're not at liberty to talk about the case with whomever you wish. You can talk about it with each other, with friends, with family. You can talk with the witnesses. You can talk with the lawyers. I will tell you that lawyers, in any case, like to know what jurors think after a case has been litigated. However, please understand that lawyers are prohibited ethically from coming up to a juror and asking anything at all about the case. You can speak with the lawyer if and only if you approach the lawyer to engage the lawyer in conversation. I'm not suggesting that you should or shouldn't. I'm simply letting you know that if you want to talk with the lawyers, you'll have to initiate that. Also, you all have been really, really good about not letting the media, not being exposed to anything in the media. I will tell you now that there's lots of media attention with this case. That's why we had to go to Orlando to get a jury and come back here to Hillsborough County. There's lots of media interest in the case. You may be approached by members of the media. You may not be approached by members of the media. You're at liberty to talk to them if you wish. You don't have to talk if you don't want to. That's your call and your call alone. With respect to getting you back to Orlando, I think the deputies are going to handle that for you. Any questions of us before we recess you? Okay, I do want to thank you all, and I truly apologize for having you have to come back, and we really can't tell you how much we appreciate the service that you extended. These are rare cases that we have, death penalty cases. They happen infrequently, thank goodness. So you've experienced sitting through a death penalty case now in your careers. You're welcome to stay in the audience if you'd like to do that. If you want privacy, the bailiffs will handle that for you. Just let the bailiffs know what you wish to do, but I'll discharge you at this time. And we have jury services letter for them? Yes. We have letters?
Well, in a minute, Judge.
We'll get jury services letters for you. Any questions or concerns before we recess you? Okay. Thank you all again. Thank you. Thank you. seat, I'm sorry.